Hilary Calvert.
Thank you, Mr Speaker. My question is to the Attorney-General. Will he support my proposed amendment to the Marine and Coastal Area Takutai Moana Bill to include a specific prohibition on customary title holders charging for public access to New Zealand beaches, such as is provided for in the Foreshore and Seabed Act 2004? If not, why not?
The Honourable Chris Finlayson.
Mr Speaker, the bill as drafted does not allow customary title holders to charge for access in the marine and coastal area, and I refer the Honourable Member to clauses 27, 60 and 63. However, it has been suggested that the bill could be made more readily understandable by inserting a direct statement that charging for public access is not allowed. That is something I'm certainly willing to consider, and I'd welcome receiving the member's proposed amendment.
Hilary Calvert. Order. Hilary Calvert. Hilary Calvert, please.
Does he consider a couple having their wedding photos taken on a beach to be a simple issue of access for which customary title holders should be prohibited for charging? If not, why not?
The Honourable Chris Finlayson.
Under the bill as drafted, it is not possible to charge for public access. A customary title holder will have the right to permit or to decline activities that require resource consent, that is, activities that have a significant environmental impact. I wouldn't have thought that taking wedding photos was unlikely to require resource consent.
Hilary Calvert.
What redress does he think there should be for wedding couples should local iwi demand payment for photos on the beach?
The Honourable Chris Finlayson.
Mr Speaker, as I've said, there is no right to charge for public access. I think the example the Honourable Member may be referring to or has alluded to may have happened actually under the existing law, not under what is proposed in the bill, because of course the bill hasn't been enacted. We currently have laws in place which prevent people from restricting New Zealanders' lawful freedom of movement and freedom from intimidation, and this legislation won't change that position.
Te Ororoflavo.
Thank you, Mr Speaker. To the Attorney-General, does he recall his statement in the House at the first reading of the Bill 15th of September 2010 that about the rights associated with customary marine title, that those rights do not include charging for access? And what does he believe is the motivation for certain parties to continue to talk about charging for public access when such a concept does not even exist in the bill?
The Honourable Chris
Speaker. Yes, I do remember the statement and I stand by it. The bill does not permit charging for public access. I can only assume the motivation is the desire for absolute clarity or because of some confusion. And as I said, I'm happy to consider any matter that satisfies the legitimate concerns of those parties.
Question number 2, the Honourable Leader of the Opposition.